I am honored to introduce Professor Melissa B. Jacoby to all of you. She is the Graham Keenan Professor of Law at the University of North Carolina at Chapel Hill. A frequent commentator on bankruptcy and debt in national media outlets, she has published over 50 articles, book chapters, and op eds. Tonight, she will be talking about her new book, Unjust Debts: How Our Bankruptcy System Makes America More Unequal, which has made the Financial Times Best Books of the Summer list. In this important work of legal scholarship, Professor Jacoby highlights how bankruptcy court is being used to circumvent accountability and consequences by the powerful in the United States, which reinforces the many persistent inequalities of class, race, and gender. In a starred review from Publishers Weekly, they write that Jacoby's assured prose brings extraordinary clarity to an intentionally opaque and labyrinthine system. It's an eye opening look at the laws that undergird American inequality. Professor Jacoby will be in conversation with Vicki Shabo. She is a senior fellow at New America, a gender equity expert, policy advocate, and coalition builder who has helped to win paid leave, paid sick time, equal pay, and pregnancy fairness policies affecting tens of millions of people. Her opinion pieces have been published at the Boston Globe, CNN.com, New York Times, and the USA Today, among others. Everyone, let us all welcome Professor Melissa B. Jacoby and Vicki Shabo.
Hi, everyone. Hello. Happy post 4th of July. It's really great to see everyone. I love having people under 10 in attendance especially. So I love an all ages event. So thank you all for being here. Yeah, it's great to see folks at my hometown bookstore. Super excited to be in conversation about this book. We were chatting. I actually went to UNC Law School and graduated quite a number of years ago. Did not take a bankruptcy class, did not take any commercial law classes, took things like, administrative law, which doesn't matter anymore, apparently. But I'm super excited to be here. Melissa and I actually got back in touch when I started working on paid leave and some of the research that she had done with Senator Warren back in 2006, I guess, really focused on the relationship between pregnancy and becoming a new parent, medical issues, caregiving, and people going into debt and turning to bankruptcy. And so I feel like we often, particularly in this town, work in policy silos a lot of the time. And I love that this book and this body of work really breaks those things down. So we're going to focus a lot on that.
And I'm glad that Vicki ultimately realizes that she might have actually enjoyed classes about money, that they related to things that she cares about. So this is a good reckoning we're having right
It's fantastic. Yeah, I'm just excited to be here. I feel like we should say we are two white women sitting up here. We know that the issues that we're going to talk about often affect communities of color disproportionately. And so don't take that or the privilege of being up here lightly. So we will, I guess, get to questions. I'm going to start where you start at the beginning of this book, which is around the relationship between caregiving and bankruptcy, financial challenges, and bankruptcy. So you start this book with sort of a composite of a woman named Sylvia who has job and work interruptions because she's been caring for her mother for, I think, 5 years. And some of your early work, as we've talked about, relates to these relationships between care, which all of care responsibilities, which almost everybody has at one point or more in their lives, and financial challenges. So just as by way of background, in this country today, 53 million people provide care to a loved one or a child with special needs. Most of them work, and only a minority of people have access to paid family leave, paid medical leave for themselves, workplace flexibility or scheduling control, or even paid sick time, and other policies that are needed. And those who do have access to these policies are disproportionately higher income, white, privileged people. So I guess I'd love to start with sort of just understanding how common are the dire straits that people like Sylvia find themselves in, and how do they make it through finding financial relief through bankruptcy or otherwise, and sort of what are the barriers that they face?
I started my career after law school at a bankruptcy court. I was a law clerk to a judge, Bob Ginsburg, in Chicago. I'd never been there before, other than for the interview. I rode overnight in a cargo van to move there right after taking the bar exam. And what I saw right away were people like Sylvia, who do face a range of calamities, trying to do everything right, trying to be reasonable, trying to manage their obligations, but life happens. Job problems happen, caregiving happens, and we are in a society that puts a lot of risk on the household level. No matter where someone's politics are, that is just the fact of how we do things here. So there's one thing looking out in a bankruptcy court and trying to figure out what's happening, but that really only gives a partial glimpse. So later, I was involved in studies of people who filed for bankruptcy over quite a number of years. We look at all of their files. We ask them questions. Sociologists ask follow-up questions and design ways to see how they're doing over time. And Sylvia really captures, Sylvia is the character in chapter 1. She really captures many of the features of bankruptcy filers, and is a useful person to keep in mind when thinking about how you design the system. Bankruptcy doesn't print more money. It doesn't create paid leave. It doesn't create caregivers. It's a very blunt instrument that has support really across the ideological spectrum, at least among economists and others, to cancel debt when needed. And it is something only the federal government can do, but it only goes so far. So whatever else you would like to see in a society, whether it's a government that does more, whether it's the private sector that does more, whether it's the nonprofit sector or a mixture, bankruptcy is a piece of the puzzle, but it's never going to be the whole thing. And one story of the book that I saw, and some of the people in this room have experienced this in their professional lives, is that in the course of my career, I have seen bankruptcy become more expensive and less effective for the most financially distressed people. And it's not that put more money into creditors' pockets. It didn't. The studies basically show that. It just doesn't make a lot of sense.
Yeah. I think you referenced Jacob Hacker's Great Risk Shift in this book, if I'm not mistaken. And I was thinking all the way through this book, all of the different ways in which risk is shifted from systems and entities that can afford it to individuals. And I think nothing really points that out more than the second chapter, which goes further into personal bankruptcy and the racial injustice components to it, and how systems of systemic racism, things like higher mortgage rates and car loans that are predatory and student loans that are predatory, combine to make financial challenges even worse for communities that are underrepresented. And then you also, I loved at the end, pointed out how unrepresentative the people who are making these rules and policies, who are lawyering in these cases, who are adjudicating these cases are. And so you have kind of people who are disadvantaged by decisions that other people have made, and those people look nothing like them. So I'm curious if you can talk a little bit about sort of how the systems might be different if the people who were creating the systems looked different.
We have two things going on at the same time. We do have a population of really hardworking, dedicated professionals who work in the bankruptcy system. And we might read in the Wall Street Journal and the Financial Times about some who do really very, very well. Their careers are very profitable. But that's not true across the board. It's certainly not true for the vast majority of lawyers who work in the system, of those who work at the Department of Justice who oversee the bankruptcy system from the administrative side. We have a really dedicated bankruptcy court that's part of the federal court system in this country. Overall, everything we know is that it doesn't match the people who are using the system. It doesn't match America. And indeed, African-American families are overrepresented in bankruptcy, and particularly the part that the type of bankruptcy that is more expensive and provides less debt relief, even when controlling for pretty much every variable that you can imagine. The studies have been done over and over again. So on the one hand, we do have a pretty homogenous set of professionals. And on the other hand, we have a set of laws that on the books already bake in some race inequality because of the way they deal with debt and assets. And then we add on practices and stereotyping and other aspects that people have studied. Now, how related are the two? Well, we know that correlation does not equal causation. I think both should be fixed. I actually think it is easier to fix the statutory problems than diversifying the bar, although again there are efforts that have been made on that front as well. And I want to say that bankruptcy judges have been on the forefront of trying to diversify the pipeline, open it up to more people who didn't think they could be a lawyer, who didn't think they could be a lawyer who deals with issues of money, and certainly didn't think they could ever become a bankruptcy judge. So I want to recognize the efforts of bankruptcy judges, lawyers, and some professors in working on that effort.
Yeah, that's great. You sort of have this dichotomy in the book between real people who are going through the system and who have a set of rules and expectations and assumptions that are imposed on them that sets a very high bar, both for filing for bankruptcy in the first place in some cases, and then certainly for discharging debt. And then you talk about fake people, and fake people being corporations and nonprofits and other associations that are using bankruptcy either to go out of business or to restructure, or in some cases to avoid tort liability. And so this has been in the news recently. I'm wondering if you want to talk about that little case, the Purdue Pharma case, and sort of...
Wait, what case was that again? I don't think I've heard of that.
About chickens or about drugs or about opioids? I don't know. This family named the Sacklers. I don't know. There was a decision handed down a couple weeks ago that is very relevant postscript, or maybe just the next chapter for the first chapter of your next book. I don't know.
The next book is on a different topic, I promise.
But talk a little bit about that case and what the resolution meant and sort of how it's emblematic of this broader set of really fantastic in like the worst way, and horrible cases where people have really been harmed.
I am happy to do that. Let me first talk a little bit more about the fake and real dichotomy, since you've raised it.
Right.
And if I digress, please get me back on track to make sure I address the Purdue question. So I talk about fake people as a big category. I don't mean it to be pejorative. I understand that some lawyers or others might think I mean that. But it's one syllable. You can say it so much faster. It also isn't just private or for-profit corporations. It's cities. It's sewer systems, it's public hospitals, it's nonprofits. These are all based on the business association as being a separate legal entity. That's really important in how we structure our society. The question is, what attributes do we give fake people, and are they treated better than humans? Now, this comes up a lot in Unjust Debts because if you hear me talk about personal bankruptcy, you might think that Jacoby is someone who believes, well, the federal government can solve everybody's problems, and if we only had more resources and let it do more things. That's actually not really where I fall. I think that what I'm asking for in personal bankruptcy is the narrowest construction of the bankruptcy power, which is part of the Constitution, to provide debt cancellation, legal obligations. When we get to the corporate side, and I'm including cities, but including nonprofits, but especially big corporations, which are going to get a lot more of this than small businesses, which are treated a little bit more like humans in bankruptcy, although things have gotten a little bit different recently. For big businesses, the law is pretty expansive. It is an expansive interpretation of federal court power, and that is overriding all the things that states are trying to do. That is overriding individual liberties and rights. It is changing a lot of other laws. So when I look at the bankruptcy power and I see what's happening with fake people, with big corporations, I say, wow, that's too much. Are they doing the things at least that were supposed to be done that justified a big bankruptcy power for businesses? talked about, well, saving jobs, supplier relationships, promoting competition by keeping more businesses alive. It turns out, though, when we take a close look, that that's not exactly what's going on with big business bankruptcy. So there are two types of problems I see with big business bankruptcy. One relates to when it's used exclusively or primarily to deal with a mass tort problem. And the rules were really based on contract creditors and lenders renegotiating payment schedules and that sort of thing, not a whole other set of issues. The other that's encapsulated in chapter 5 of the book is when parties want to use, they want the benefits that federal law is providing in the bankruptcy code, but they don't want all the checks and balances, the bells and whistles. They don't want the package deal. They want to make it an a la carte menu rather than the whole thing. And I'm really worried about the distributional effects of that. And I also worry about why the federal government should be handing out these perks and overriding state law of a wide variety of subjects without accomplishing the main objective. It also underrides or overrides the rule of law. It undercuts the rule of law. And that is of big concern to me. So let me go talk about Purdue for a minute. Who here knows anything about the Purdue Pharma bankruptcy? I'm not going to call on anyone except maybe some of my former students. No, I'm not even going to do that. Okay. Or some of my law school classmates might want to chime in, of course. So let me just go about it a different way, because I'm guessing more people know about Purdue Pharma than just raised their hand. I'm just going to say. But let's imagine that you are all of you have been injured. This is all hypothetical. And Vicki and I, who are in real life really peace-loving people and care a lot about your well-being, have focused on, we really wanted to make these products. We really wanted to push these products and sell them. We made a lot of money off of it. And that's how you all got injured. Now, I go into bankruptcy. I say, I really need the bankruptcy system to help me out here, because I got all these people who say that I've hurt them. And wow, there are a lot of those people. And, I can't name them individually. There are just too many. And some are more hurt and some less hurt. Forget about all that. I need a way to just wrap this up, cap their liability, and be done with it so I can go on with my life. Now, let's say I get a lot of you to agree to that. You say, okay, the thing about bankruptcy is that the majority can bind the minority. So if I get 20 of you to vote in favor and 3 of you to vote against it, I say, hey, we can do this. I can bind you all. Now, you might look around and say, there are more than 23 people in this room. And my math is not great, but I'm pretty sure that's true. That happened in Purdue Pharma, and it happens in a lot of cases. Most claimants don't vote. So we don't know what they think at all. Very true in Purdue Pharma that over half of the personal injury claimants didn't cast a vote at all.
Wait, do you want to just say what the case was about?
I am saying what the case is about. I have a wind-up. See, you're right.
Sorry,
yes.
so sorry.
No, so I'm going to bind everybody to my deal. Oh, but there's another catch. Vicki, sorry, you're the Sacklers in this story. This was not planned.
Or Vicki. I'm sitting here.
Vicki says, well, wait a second. I don't want all these people coming after me. How about I put a little money in the pot, and then we're going to bind everybody, and you can't go after Vicki either. So Purdue Pharma was about whether the very powerful parts of the bankruptcy code, where I can make us the majority of people who vote bind everyone, whether we then can apply that to a third party too. Now, Vicki works at New America Foundation, a very wonderful organization. So she is not the Sacklers. But what we have here is, now we put this back into the opioid crisis. You don't need me to explain to you all the devastation that came from that. And the vast majority of opioid settlements have been outside of bankruptcy. The vast majority of opioid settlement dollars vastly exceed what the Sacklers were putting in the pot. But none of that really matters to the legal question. The legal question was whether the Purdue Pharma bankruptcy can protect the Sacklers who did not file a bankruptcy petition, did not disclose all of their assets to the public, and is not bound by the same rules. And a bare 5 members of the Supreme Court said no. Mixed ideologically, this one was never going to come down on the lines that people assume for other cases, but that the Sacklers could not get that protection from the Purdue Pharma bankruptcy. Now, that doesn't mean that each individual person who wants to settle, you have the autonomy to do that. That's a contract. Nothing about this affects that. The issue is forcing you to give up your rights against someone not in bankruptcy. So really, you have a bankruptcy system, and then you have 2 people who are not in bankruptcy. And how the bankruptcy system, say, lawyers for many years, should be able to change the rights between those third parties without their consent. That is the issue. I took a while to get there, but I think sometimes it's all about like good guys and bad guys and all of that. And I really want to generalize the issue. It really is about coercive federal court power and changing your rights without your consent and how broad that goes. And I think that's a really important point. Whatever you think of the Purdue-Sackler settlement, and settlement is not quite right. It's a settlement when everyone agrees to it. It's not a settlement when you apply it to people who did not consent.
Gotcha. Can you you mentioned municipalities also, and I was very struck by the Detroit example that you gave and what that meant for people who were living there. And so again, like I think about all of this as what does it mean for people, and I know you do too. So can you talk a little bit about that case as well?
Yes, and I think it's important to mention or to recognize that someone can care about the economics of the situation and the rule of law, and also care about the people. You can do all those things at one time. So municipal bankruptcy, and we briefly had someone here who's written a whole book about the Detroit bankruptcy, but who has done a talk here in the past, Nathan Bomey. But what I focus on in Unjust Debts is a particular group of people who was affected by the Detroit bankruptcy. Detroit was the biggest city ever to file for bankruptcy, and no one really knew how that was going to go. And it went through much more quickly because of some very powerful forces trying to encourage settlement than anyone thought was possible. It was in and out of bankruptcy in 18 months. Anyone here from Detroit? All right. Someone watching me careful to make sure I get this right. That's good. So I look for people to tell us how Detroit is doing now. There was a lot of focus on 2 big groups of people. Again, people broadly. One is retirees who worked for the city and were wondering about their pensions and their health care. Also workers who were still working for the city and what was going to happen to their contracts and their benefits. Another was all the money that Detroit borrowed over many years on some very exotic kinds of investment contracts, some of which just didn't quite pan out, even though some of those very complicated deals won all sorts of awards from those who give out those kinds of awards for fancy, complicated things. But ultimately, Detroit really did have a financial problem. Their street lights aren't all on, their ambulances aren't coming. The quality of life for people would suffer. A lot of that I've written about in other work, and again, there are books about the entire case. What I focus on in this book is people who say that they experienced police brutality or other civil rights violations, something that Detroit has a history of, and so do other cities that have contemplated bankruptcy or gone through bankruptcy. And what we need to understand, and this is a lesson for all kinds of bankruptcy cases, is how broadly the bankruptcy system defines a debt. Before I started working in this area, I think a debt, I borrow money, I have a credit card, I get a loan, a bond in the bond market. But the bankruptcy system says any legal liability that's payable with money is a debt. And that includes suing the police for a violation of your constitutional rights and having physical harm and sometimes death. So all of that gets swept in. And what we see in Detroit and other cases is that there's no room at the bargaining table for this population of people, civil rights claimants, and they get the lowest payout really of anyone. And in addition to that, what they're promised, another theme of bankruptcy plans, what they're promised and what's delivered are sometimes very different. So in Detroit, they were promised 10 to 13% of their claims. They'd get it over time. It turns out 5 years later, you needed a brokerage account to collect it all, but the payment was down to a couple cents on the dollar. That made settlements fall apart. It was very difficult, I think, for people to ultimately even get that compensation. But ultimately, those cases are not only about money, they are about accountability. And so bankruptcy is saying something about that. And then it goes even farther in cities that tried to then protect their police officers for their own independent liability. Now, after Purdue Pharma got ruled on by the Supreme Court, that's going to be harder to do. So keep your eye on that dynamic.
Interesting. So all of this, as I was reading this book and as through this conversation, sort of goes back to like these two sets of rules. And under these two sets of rules, you have individual people who are forced to make everything about their finances transparent. They are forced to pay a bunch of money to be able to use the bankruptcy process, and their debts aren't discharged until they're done. And then you have the fake people who can set up a plan, and as I understood it from reading the book, you can tell me if I'm wrong, as soon as they have this plan approved, they're sort of considered to have been redeemed. And you have people who are standing in line as creditors, who may not think of themselves as creditors. They think of themselves as like potential civil litigants in a case. You have other people, retirees or pensioners or other people who are standing in line, who may or may not see the relief that they need. So these rules are obviously set up in ways that are unfair, and some might say rigged. And it just struck me, as so many things do, that our laws are products of an uneven playing field in terms of how we're making laws, whether we're thinking about lobbying and corporate interests in the lobbying process. You talk a lot about credit card companies and the role that they played in the 2005 bankruptcy reform, about the well-heeled lawyers who have more power in these processes. And I'm just curious if you can sort of reflect a little bit or just share your thoughts on how connected are these problems that you're seeing here to much broader systemic things that we need to solve and lock arms to solve? How much of it is related just to bankruptcy, and like, what do we do?
Sure, and I appreciate you. You've encapsulated, you practically get an honorary A in bankruptcy class for answering a question that I over time I started introducing more, which is to compare how an individual is treated with a corporation. Not all cases or professors would think about it that way, but that the rules are different. Those are rules that Congress wrote. So a lot of this starts with Congress wrote different sets of rules for individuals versus companies, cities, and the like. And I don't think it was motivated by any express bias. I do think there are value judgments that go into saying we need to make sure that an individual, however low their income is, we better make sure they're not having any enjoyment or any part of their life that's going well at all if we're going to give them debt relief. And by the way, we want them to pay a lot for the privilege of getting it. We flip over to the big business side and it says, well, you're a big business. You hire fancy accountants and financial advisors, and now we're going to call them restructuring professionals because that sounds, it's important work, and they work very hard, and it costs a lot more money. And say there's more deference there, and that deference is baked in to the law itself, into what Congress wrote. It's also evolved in practice, that we see differences between the flexibility that's given to big businesses versus individuals in the system on a day-to-day basis. And then over time, it's like, you know, when you're hiking and it says you have to stay on the blazed path, right? But then if too many people cut over, you start getting confused. You're like, well, this is a path. This has got to be a path too. And so everyone starts going that way. That's what happened in Chapter 11. Lots of shortcuts on the path, quick sales, and again, using the benefits without all the burdens. Leading, again, I'll ask the question again, this is a pretty big federal power to be using if we're not sure why it's being used. And it's not being used in accordance with the rule of law. Now, some of these could be easy to fix in theory, and we can talk about why I'm a little bit optimistic that it's possible that some of this could be fixed. But I think it is also true to look at the broader context. So I caught just a bit of the Daily Show where Reverend William Barber was on being interviewed by Jon Stewart. And Reverend Barber was saying, as part of his Poor People's Campaign, and really just trying to mobilize people to vote, but he said that, and I won't get the quote exactly right, but people look at low-income families and say, oh, they're asking for so much, they want entitlements. And he said, really, it's really big corporations that expect federal government entitlements. And wherever one falls, I don't think we can deny that that's true. It's not a message of get the government off our back, although it's framed that way sometimes. It's put a thumb on the scale for my business to grow, not necessarily to compete, but to grow. Now, of course, I'm overgeneralizing. And again, I also want to distinguish, I think small businesses are in a really different situation, both in bankruptcy and in general. So it is tied to broader themes, both in how we value, who we defer to, and this is a class message, in terms of who's allowed to sort of push for more discretion, as well as who has power to make the laws as they are. So it's easier to change bankruptcy than it is all of those dynamics.
But yeah, I mean, it just strikes me time and again in the work that I do and in the work that other people do that seems relevant. It's like the rules are rigged. Like we're all, in many cases, sort of working to advance issues on a chessboard that is like tilted into the ocean is sort of like a very mixed metaphor that I sometimes find myself using, which is who has power in Congress? How are we writing campaign finance rules? How are we writing lobbying and ethics rules? How are we thinking about voting rights and redistricting? And how is it that people who are working in individual silos across issues start to work together to fix some of these systemic problems that are leading to unequal outcomes and processes?
Yeah, and I think I would just add to that to say, and you and I may not be on the same page on this particular issue, but why what I see going on the state level of some alums who are working on state policy of all different types, why it's so important to let the state law flourish and have that laboratory. And certainly this is true in consumer protection and other areas, and ways to promote competition that might be just too hard or too big, or maybe it just is too much for the federal government to take on.
Yeah, totally. So, big fan of states as laboratories. Yeah,
states as laboratories are super important. So I don't want that message, at least from me. And again, people, this room will have a lot of different views in it, and I respect that. But I think that what I'm worried about ultimately, and why I wrote this book for the general public, is I think bankruptcy is flattening too many other policy issues that are dealt with by other parts of the federal government, by states, local, by contract, by public-private partnership, all of those things. And it really needs to focus on its core mission, which I think it's fallen short on.
Yeah, you did. I really appreciated the points that were in here throughout, too, about how federal bankruptcy is cutting off rights under state court law, like state laws as well, for some of these folks. So that sort of brings me to my last question that I was hoping to get a read on, which is, what do you think the prospects are for a reform that would move the system in the direction that you're talking about? And in the absence of that, are there examples that you know of, pilot programs or other Know Your Rights examples that are getting to individuals who are either needing to file for bankruptcy or having their rights affected by corporate enterprise cases? And what do you think we can do to help empower individuals in this process?
Well, since I'm in Washington, D.C., I'm going to speak extremely authoritatively on this and say this is exactly how it's going to happen. No, I don't have a great answer to this, but I can give pieces. So one is in 2005, when Congress made a lot of complicated, expensive changes to the bankruptcy code all the way through, but especially burdening debtors and creditors in consumer bankruptcy cases and small business cases. And that was a real concern. In 2019, Congress switched course on small business on a bipartisan basis. I say this often. Sometimes I like what they do and sometimes I don't, but it is almost always bipartisan that bankruptcy legislation happens. And that was true in 2019. From all indications, and people in the room know this better than I do, that's working very well. I see that as a sign that you can make at least targeted changes to the system. So, for example, there is a proposal to simplify the consumer bankruptcy system. It's been well developed over a long period of time. I would love to see it reintroduced as soon as it can be. There are a lot of other pieces of the puzzle that have been floated. We also do see innovation on the state level. Again, some of this, I think, risks being overridden by bankruptcy. So some states, in their concern about the legacy of cover-ups of child sex abuse, have not only opened their courts to say, you are, as an adult, when you feel ready, you can come forward and try to seek some accountability. They also call for training of their judges and their justice system and protocols to make those more well-tuned to the kinds of problems they're going to be discussing. So that's the kind of thing I don't like to see bankruptcy override, although it could take some lessons from that and try to incorporate some of those things. But again, that laboratory, we do see that court systems, whether or not they are always the right place for certain litigation or certain accountability, that there are things that can be done to not just say the status quo is the status quo. So I think I'll stop there.
Any examples of sort of know your rights? I don't know, ways of dealing with this issue now.
Thank you for reminding me. This is why you have to have an interlocutor. I'm going to invite, when we get to the questions, I'm hoping someone in the audience might talk about some know your rights, really cool projects that are going on right now. Hint, hint, Professor Jimenez. Or anyone else who'd like to talk about these things, who can speak with much more particularity. I think those know your rights experiments are important at the state law level as well as the bankruptcy court level, because we know that sometimes someone has a collective financial collapse. That's a lot of the situation in personal bankruptcy. If someone is having one particular kind of debt problem with one creditor, that's not supposed to be bankruptcy territory, but state courts and debt collection, that is keeping courts very, very busy, and too many default judgments that are being issued. And there are consequences that come from that when someone can't miss a day from work to go to court and the like. So I'm really inspired by some of the projects that are going on right now to understand what's going on in those systems. I'm hoping others, this is a learned audience in a lot of different ways, so I'm hoping things that aren't coming to my mind will come out from the crowd.
Well, that is perfect segue to audience Q&A. There's a microphone up here, and ask away.
I'd like to talk about, as an ex-real estate lender, I've had my share of bankruptcy court attendances. But I'd like you to speak about the shielding of liability, and the one case I was thinking about was the Boy Scouts. Mm-hmm. And how is it still going on? 1, 2, does the bankruptcy shield the liability, not just the money?
Yes. So thank you for the question, and I think I can answer that. So the bankruptcy does shield liability. Let's look at Boy Scouts. The Boy Scouts case, the main part of the bankruptcy is over. The plan was approved by a court. It was approved by a second level of court, and then it went into effect, which means a pot of money was created and protocols were set up, and money has for over a year has been worked to set that up and has been handing out. I think the last I heard was they've handed out about probably 15 million or more to this point, which is a small amount relative to what else is coming. The Boy Scouts plan shields the National Boy Scouts, which was the debtor, and then under a variety of sets of circumstances would shield local councils and organizations that also worked with the Boy Scouts. It does not shield individual perpetrators or alleged perpetrators of abuse. Those are carved out separately and not part of that. But we are in the phase of people telling their stories more to this organization that's been set up, a trust. They have very extensive information to fill out, to share with the trust, and the trust will make decisions about payouts. It's only going to be a small amount of money at first because the person overseeing the money is trying to be equal, everyone getting an equal percentage of their claim. So it could be a long process for people.
So I'm a lawyer too. I didn't take bankruptcy either.
I forgive you.
And I graduated in the early 70s, and I didn't like the way law was going, and I got so disgusted that when I was 40, I went to medical school, and I praise God every day that I did that, especially this week. My question is, did you look at pensions? And my late husband was Marty Slate. He was executive director of the Pension Benefit Guaranty Corporation in the Clinton administration, when all kinds of companies were manufacturing a bankruptcy so that they could drop their defined benefit plans, transfer whatever was in the fund to the PBGC, and it was all through bankruptcy. There was the corporate raider who took over TWA was calling our house every week. He was trying to put TWA in bankruptcy so he could drop the pension plan. And after Marty died, he did. Do you talk about that in the book?
I do talk about the TWA bankruptcy.
Oh,
yes.
really?
The third one. I mean, there are a couple. I do. Now, I had to make some hard choices in this book so that you would be willing to read it. And so I focused on bankruptcies that went in a less traditional path in the two respects I described. One, quick sales, which the eventual TWA bankruptcy was that. And they dumped a lot of things through that and then were bought with no successor liability.
Right.
And so they did get that, and the Third Circuit Court of Appeals upheld that and said that, well, we have to let that happen. And there were also sex discrimination claims in that case that ultimately were not going to be honored because of that. The traditional Chapter 11 that also has a defined pension plan. I think it's fair to say there are fewer of those pension plans
Hardly
now.
any.
Well, right. So that means that they occupy there are fewer of those bankruptcies because of everything that you've seen.
They destroyed defined benefit plans.
I will defer to you on that because I can't answer that question. That's out of my expertise. But I think there is some really good research written about this. But I would also generally say I want to think about workers for just 1 minute, and then I would love to answer your question. We need to look at how workers are being talked about and used in business bankruptcy, especially because it connects with your work, Vicki, in another way. Bankruptcy, Chapter 11, this idea of keeping a business alive, was done a lot for arguments about saving jobs. So you will hear over and over again in any bankruptcy, whatever we're going to do, it's going to save jobs. Now, how you document that and whether it's true, I also talk about that in the book in cases like the Weinstein Company, Remington, the ammunition and guns company. So saving jobs, there's arguments that you don't always want to use bankruptcy to save jobs anyway. I'll leave that to the economists. But if people are going to argue that they're using bankruptcy to save jobs, they either need to follow the blueprint of the bankruptcy code, the rule of law, or, I mean, I would stop there. But if they're going to say they're going to save jobs, I'd like to see some more proof than just throwing it out there. Yes, sir.
Okay, I had two quick questions. First, do you have any thoughts about, I mean, you talked about the Sacklers. Okay, so they're the rich, but the more nominal, just rich, like taxi cab owners who set up limited liability corporations so that each taxi cab is its own company and you really have no recourse, or a landlord who creates limited liability companies for each of his studio apartments. And again, so there's not enough money at stake to pursuing. I'd be curious if you had any thoughts about remedies to that. And I'll just put out my entirely separate question, which may be beyond your scope, but your comments about the Detroit bankruptcy sort of triggered my mind. There seems to be with respect to the whole so-called Social Security dilemma in the U.S., this emerging consensus between the right and the left that the solution is to cut back benefits by basically eliminating cost of living increases for what they would call, of course, it'll be framed as, well, Warren Buffett and Bill Gates obviously don't need a cost of living increase in their Social Security benefit, but it'll be a widespread reduction, for about 50%. And there does seem to be that consensus emerging between the parties that that's the way to address the issue. So gradually over a 15-year period, everybody's Social Security will be about the same. That is to say, at the lowest current amount. So I was just curious if you had any thoughts about that.
So on the second question, I have a narrow thing I can say about the cost of living adjustment. And since who here has been living for the last couple of years? Okay, you're supposed to raise your hand. But we all know that cost of living is not nothing, and that it can go up quite a bit. One thing I learned from the Detroit bankruptcy is that when cost of living was cut for retirees, some financial creditors took that as, well, they didn't take any cuts. That was just that they counted that as not a cut. I said, no, that's a real cut. Cost of living adjustments, especially people had retired somewhat early, they had been in hazardous professions. That was real money that they had given up. It's the same as other cutting in other ways. So I'm interested in the narrative of how you even talk about cost of living and whether it's real money that you're giving up or not. So thanks for raising that. In terms of the creative use of creating fake people. So we're back on that. This is what some of my colleagues in the legal academy would call asset partitioning, and meaning that trying to create ways of, I'll go with the front row. The doctor says protecting money, and sure, that's fair. So I think what's necessary in that case, so some of those issues may not end up in bankruptcy if they really are two-party disputes. And the taxi cab situation is complicated by those medallion loans that, as collateral, that plummeted in value, thank you to Uber, et cetera. But I think that if there are more two-party disputes, it's unclear whether they should be in bankruptcy as the place to resolve that. State law is meant for that, the debtor-creditor system there. Otherwise, it is really important that any law that is trying to keep that kind of company alive strikes a balance between the rights of those creditors and the debtor and makes sure that those rights are fairly honored and that everyone gets to be heard. I think that's super important for, for all cases, but the small ones too. So thank you.
Hi. Couple of things I wanted to raise, and you can choose. One thing is advantage. I mean, let's face it, we're hyped to get our advantage. So be it a corporation, be it an individual. I'm going to segue into the individual. Our system basically runs on debt. I mean, it's what keeps us all going, period. So my point is, how are we going to back out of this tremendous dependence? I mean, all of us, everybody wants to see, if you're horrible in debt, a way to get out of it. In other words, life has to go on, and cities have to go on, and corporations have to go on for whatever reason. But my point is, right now, we're not making good decisions. and you raised that point. And the decision-making process is so askew now that it can't deal with these types of issues that you're raising. This is one part of a whole fabric of what's going on right now. And I'll turn it back.
Thank you. So I agree, especially with the system that has one superpower primarily, which is to cancel debt. How does a person then move on? They're allowed now. The markets are allowed to discriminate against a person who has been through bankruptcy. That is permitted. It is not. There are pockets of exceptions to that, but for lending, it's basically true. But in a society that fills gaps with credit, and where people are in risky situations, whether they want to be or not, how to avoid ending up with people back in debt, I think, is something that bankruptcy cannot by itself answer. It is part of the broader fabric of the private social safety valve, so if you will, of using credit, because when there aren't other options. Sometimes people do that, and in the interviews bear this out of people. They'll sell everything. They will use fringe credit. They will do anything to not go into bankruptcy, and they end up there anyway. And but some of those same problems could happen again. But bankruptcy can't, on its own, resolve that issue. It's not a financial education issue. Now, we do have the question of whether, when people are under very significant, stressful situations, how that affects their own decision-making processes. And I haven't studied that directly, but I think there is good work about how that affects people's decision-making. But I think what you're raising is way bigger than, it's not individual decision-making. That's really kind of the point. These are structural decisions as a society that have been made, and they do fall on the individual and family level. Thanks.
Thank you.
I have a quick question. I was wondering, I don't know, maybe you have not studied this, but I was wondering how bankruptcy compares to other countries. I'm European, so obviously I'm wondering about how the social welfare nest in Europe maybe prohibits the consumer bankruptcy policies that we have here, but can be anywhere around the world, doesn't have to be about Europe.
Well, thank you for the question. One big hole in this book, again, keeping it less long than it otherwise would be, is it doesn't engage in comparative work. Earlier in my career, and again, I think there are people in the room who also have been involved with this, I was more involved with a sort of international discussion of comparative consumer debt analysis. And what I think we found was that some countries that had more robust safety valve said, we'll never go where America does. America's too lenient with allowing people to cancel liabilities. That seemed like it went very far. What happened, though, is that consumer credit markets caught up with various countries and realized that bankruptcy is a response to that kind of robust and sometimes expensive consumer credit. So I think that relationship is an important one, and that we probably are seeing more convergence around the world, but I'm still hoping, even though America is often used as a model, both on the personal bankruptcy side and business side for other nations, I'm not completely comfortable with the model because of the reasons expressed in this book. But you're absolutely right that there should be different trade-offs depending on what the other social protections are in an economy and in a society.
So you mentioned the restructuring professionals.
Yeah.
And the vast array of individuals who work on these, I guess, larger cases. Have you looked at the impact of the fee arrangements and the impact on the bottom line pool available to potential claimants? And if you have, I'm wondering what your thoughts are for scaling it back, reducing that impact for the future.
Sure. So there's a robust debate about the role of fees and whether these companies and their claimants are getting the benefit of the expensive fees. There was a debate on Twitter today just about that. Yes, I still call it Twitter. And there was still room amidst other things that people were talking about on Twitter today to talk about this exact issue. And some restructuring experts were saying that they were dubious that $45 million in fees to get a company through bankruptcy quickly was inherently better than $25 million in fees, and that nobody had proven. Now, those are big numbers with a lot of zeros. There are some people who I think have tried to quantify this more. Stephen Lubin at Seton Hall is one professor whose work I would recommend looking at. But I think there's still a pretty robust debate. The bottom line is that when we're looking at the very biggest cases, the market's been a little bit captured by just a very small handful of firms. I don't know that there's a real competitive process going on there. And so one can worry that if the fees are inflated, that means that the value isn't there. But I have not engaged in robust empirical study of that myself.
Hi, Professor Jacoby. It's
Hi,
good to
Jonathan.
see you again. Yes, former student. Didn't take bankruptcy, though. Secured. And
Secured
advanced commercial.
transactions is actually the best class. Book number 2, hopefully.
It's true. It was great. So my question, well, I have a compound question, or two unrelated ones. Actually, so the first question is really about the real people versus fake people. And so you were mentioning jobs and other effects that it might have if you were going to, or that has been argued for reasons to treat fake people differently. Are there valid reasons in your mind as far as like second order and third order effects that you would consider, or do you believe that like fake people and real people should just be treated flat across the board?
So if anything, I think that real people there should be a little bit more generosity toward real people than fake people, because fake people can't just be shut down, to state the obvious, and or real people can't be shut down. Fake people can be, and we can create new ones tomorrow. So the arguments for giving more largesse to big companies has to be related to their instrumental benefits, broader economic effects, and what I talk about in the book a bit is I want to see. I don't understand why some of those same arguments aren't applied to personal bankruptcy as well. That in that situation, it's seen as if individual bankruptcies don't have broader effects, and of course they do. There's economic research about people, if they have more debt cancellation, are more likely to start a business, for example, and do other things that are going to be productive to the economy. Now, does that mean they should be exactly the same? I don't go that far, but I don't think there's been a thoughtful point-by-point consideration, so I try to identify some of those examples.
Thank you. I did have my compound question. Chevron, just bringing it up. Do you think IRS rulemaking, other like second order effects, I know it's speculative, but what negative effects, or what effects do you think might happen because of uncertainty in business given these recent changes?
Well, there are some people in the room who work for agencies, and they're probably reckoning with this right now. I am less, I guess, I'd say quickly, because there is a little bit more of a line, and it's not my primary area, that I would say I'm a little bit more reserved in trying to predict what's going to happen when you put all the administrative decisions together. I see why Vicki might say what she says about it all coming down. That's not
hyperbole.
Yes, but I don't really see it that way. I think we could ask good questions about each of those pieces, and I'm not saying each of them was justified. I don't know, but I'm willing to be a little more circumspect about that. We're only going to see little pieces of that have an effect in bankruptcy. I think the U.S. trustee and the Department of Justice is going to have to deal with some of those effects, but the bankruptcy courts themselves will not, and the rest would be too much speculation. Brian.
Hello,
I
Professor.
think you're my last question.
And the question actually is for both you and Vicki. So you spoke real briefly about cross-issue coordination or overlap, and I'd be interested in hearing about your thoughts on multidisciplinary and cross-issue coordination. You think about lawyering, policymakers, academia, legislators, and among others, frontline, call them social care workers. Like, where's the action other than legislative change? Where's the action in terms of affecting change and even things that the audience members could get, roped into?
That's a great question.
That is a great question. So I'm a huge fan of people getting together across silos and across positions to actually think creatively about the change that needs to be made. So huge fan of bringing private sector stakeholders and civil society groups and people whose lives have been impacted and legislators together to solve problems. I think this book is a great example of also bringing people together across issues to identify common challenges. So at root, like, capitalism is a big problem here.
Let me just say, though, the book is not, I don't think of this as an anti-capitalist book. I actually think that it's consistent with capitalism. One can read it that way.
No,
but
I think so too. And like, until you start to think about, well, maybe yes, you think about how the rules have been set up to disadvantage certain groups and how you even define what is a good economy. So is job creation the ultimate goal? Is money for corporations the ultimate goal, or is it actually more valuable to put money in the hands of working people? But anyway, I think, Brian, to your question, I think there's a lot of work to do, especially in this town, where people get I think anybody who works on an issue in this town is very focused on the particulars of their issue, and rightly so. That is what they are funded to do. That is sort of the thing that they know. But I think we can solve problems more creatively and see solutions and pathways and see around the corner a little better when we start to work together and share information across issues.
And that's a really good way to close this. The only thing I will add is that I think it is consistent within capitalism or in some other structure, but we'll start with where we are, to say across issues, across disciplines, does a society, when it finds things have gone wrong, need to resolve all those problems with money, or are there other approaches and paths that can be taken? Because if some of that got answered, less would be drawn into the bankruptcy system trying to find an answer. So I know I'm supposed to, we're wrapping it up right now. I am so thrilled you all came. Thank you so much for being here.